Okay, being the appointed hour, I, I'm going to start. We did kind of a all call here on our remaining bills because of time. So I apologize if we might keep some people here inadvertently, but last time I scheduled bills with intervals, we wasted the whole day, and this way at least we're going to get it done, because the foot's on the neck to get things done, just so you'll know. I want to start, we had a request to start with HB 1587, so I'll open the work session on House Bill 1587. I know the sponsor is here, and if you'd like to make a couple of comments. Here's my plan on this bill. We do have an amendment which basically changes the amount from 56 million to 28 million. I plan to have that amendment voted on today and then recess this work session until Friday at 1. Because right now the leadership's trying to amass how much money are coming through from the different finance departments for this year. So we don't know. I'm meeting at 4 o'clock this afternoon with a speaker on these topics, so by Friday at 1 o'clock we should have a resolve, and we may have another amendment. I'm not sure, but we're in a state of studied flux right now. So does anybody have any comments on 1587 they'd like to make one way or the other? Please.
Thank you, Mr. Chair, and thank you for members of the committee. For the record, I'm Representative Steve Pearson, Rockingham District 6, which encompasses Derry. Not having that amendment in front of me, I would really like to see what that looks like.
All it does is change the amount. Right now the amount is 55,900,000, and all it does is take it to 28 million. That's the only thing the amendment does. Is that correct, Mike?
Yes, the bill as introduced was to terminally fund that benefit, and it had a cost of just under $56 million.
Right.
The amendment appropriates $28 million, with the balance of the cost to be considered in future operating budgets or through employer rates.
Do you have it available?
I do. If you
Why don't you pass it out, because the sponsors asked the question, so we can answer that question.
So, for just the sake of technicality, I'm actually the drafter of this, and Representative Pratt filed it.
Oh, okay.
But I wrote it. So, and you know how that goes, right?
Right.
I mean, but thank you. Just one of the things I wanted to touch upon, and I'm certainly by no means here to steal anyone's thunder, is the situation that we're facing right now has changed in the last 7 days.
Thank you.
So, I mean, surprisingly, and unfortunately, it has gotten substantially worse, not better.
Okay.
As I mentioned in my floor speech, when this was passed as a policy piece, at the time the National Guard was being used to augment the prison staffing crisis. They have been removed from the prison system. So now the Department of Corrections can't even rely on the backfilling of National Guard troops. And I'm not entirely sure how disastrous this is going to be for them. I know that these troops barely got them to tread water. So, one of the things that, having been in the emergency services in New Hampshire for 20 years, is that there are situations that are occurring today that if someone told me 20 years ago, I would have told them they were out of their minds. As a real world example, I tested for Manchester Fire in 2001 with 400 people. Today, we have, as a matter, not only do they have no one to pick from, they've offered a job to 5 people, and 5 people have said no. That hasn't happened in the 165-year history of the Manchester Fire Department. Manchester Police is now doing recruiting as far west as Ohio. And that, again, that's something that was never even fathomed 10 years ago. So we really, truly do have a recruitment and retention problem in New Hampshire. And, one of the things that I found acceptable, back in the day was that, no one ever gets rich being a civil servant, right? And they shouldn't. But on the flip side of that, there's something at the other end. And the changes that occurred back in 2011 that were done with no public hearing, they were slipped into a trailer bill. There was some warning. Actually, one of the fellows that did some of the warning was in this room, who warned them back then and said, look, there's going to be some consequences to this. And he was laughed at. And here we are now. So, I won't get into any other policy part of it. You guys were all on the floor of the House. I mean, a veto-proof majority is a glowing example of the recognition of the situation we're in right now. So I appreciate this group, holding a work session and looking this over and really taking the deep dive that's necessary to make this work. But I just really can't emphasize enough the situation that we're in New Hampshire is getting worse, not better. So I thank you folks for your time, certainly.
Thank you. And I would comment that one of the terms that kind of I learned by going through this is terminally funded, which means it is going to fund this for the terminal periods of all employees involved. That means it's going to solve the problem forever. My attitude right now, based on available funds, is let's put a Band-Aid on it and kick it down the road a bit, because I don't know that we can afford $56 million right now. Anybody else want to comment on? Yes, sir.
Good morning, Representative. Mr. Chairman, members of the committee, for the record, my name is Arthur Beaudry. I represent the New Hampshire State Permanent Firefighters Retirement Association. I'm a retired captain from the Manchester Fire Department and a past member of the New Hampshire Retirement System Board of Trustees. And I'm here today to speak in favor of House Bill 1587. First and foremost, I would like to thank the sponsors for introducing this bill. In 2011, the legislature made some additional changes to the definition of earnable compensation. They used the term vested status instead of when a member commences service on the date of the changes. What they did was create a 6-tier system. The members who were vested, members in various stages of vesting, and the members who had commenced service. Prior to these changes, the legislature had made changes prospectively and not retroactively. I believe this was the first time that a benefit reduction was retroactive. Although the courts have ruled it is legal to make these changes, morally and ethically is it right? When an employer starts his or her employment, there is an expectation that the benefits offered when hired will be there when they retire. When the legislature made these changes, I truly believe that most of them didn't know or understand the long-term effects of the changes, and if they had, would have considered implementing them for future hires only. When the state downshifted the obligation to the cities and towns to pay the 35% of the retirement cost and the retroactive changes to the pension benefits, the employee was affected both at the bargaining table and in their pensions. These changes made it extremely difficult for local communities to offer a competitive compensation package to attract new employees and retain existing employees. Past legislative changes have proven to be beneficial to the long-term viability of the New Hampshire retirement system, but at what cost to the employee? This committee heard testimony last week on House Bill 1417, where the Speaker explained what they did was to balance the budget. The Speaker testified that the Finance Committee reduced benefits and increased employee contribution rates in the attempt to balance the budget. These changes to the plan benefits allowed the local employer rates to go down. Is this just a shift in benefit obligation from the employer to the employee? Under Section 18B, average final compensation shall mean, for the purposes of inclusion in this calculation, the average percentage of compensation paid in excess of the full base rate of compensation in the highest 5 years shall not exceed the average percentage of compensation paid in excess of the full base rate of compensation over all the members' years of service on or after June 1st, 2012, but excluding the highest 5 years. You can see, you can't have an average over a member's years of service without including the member's highest 5 years of service in the calculation. Using the term over the member's years of, all the member's years of service is just that. Excluding any part of the member's service in the calculations would no longer be the member's years, all the member's years of service. This is taxation without representation. We ask that you support the language submitted in House Bill 1587. By doing so, will truly allow all the members' years of service to be calculated. Again, we ask that the committee support the passage of House Bill 1587 and reinstate the benefits expected by the employees when they were hired. I handed out a spreadsheet, and on that basically shows the difference from prior to 2011. The first column is prior to 2011, and I try to make it as simple as we could, where you could see how somebody could spike their pension if they worked a lot of overtime in their last 5 years. Those 5 years were the only years that were included in the calculation for their pension. So you can see somebody that firefighter A worked no overtime at all, firefighter B worked overtime in their last 5 years. This is prior to 2011. So one pension would be $20,000, the other pension would be $25,000 because they included all their years of service. When you look at the line that says after July 1, 2021, both employee and employers paid into the retirement system for firefighter B than firefighter A, more for firefighter A than firefighter B, but both firefighters received the same pension because they eliminated the highest 5 years. I put it the last 5, but those 5 highest years could be anywhere in this calculation, and it would, the results would be the same. So even though the employer and the employee paid into the system on the additional dollars for firefighter B, the results was the same for the as firefighter A, who didn't pay any make any additional contributions. And then if you look at the proposed changes, that firefighter B would receive roughly 20% of his average annual earnings over the member's years of service. So if you calculate it all, included the 5 years, it's still not like it was prior to July 1, 2011, but at least they're getting some compensation for the years of service, and I mean the amount of money they put in for those years of service, and their pension would go to $21,000 a year. So it eliminates the real spiking, but it still doesn't give that individual the benefit back prior to 2011, if I'm making myself clear. And I will answer any questions.
Any questions from the board? Mr. Beaudry, could you, if you have your written testimony, can the clerk have it to put it in the file?
I can,
Oh,
yes.
Thank you.
Thank you.
Anyone else like to speak on 1587? Yes, sir.
Good morning. For the record, my name is Brian Rill. I'm the president of the Professional Firefighters of New Hampshire, and I'm a fire captain in Portsmouth.
Could you spell your last name?
Yes, Rill, R-Y-L-L. You're welcome. I'm not going to repeat a lot of the things that you've already heard. I know you have a lot to get after this morning. I just wanted to offer a little bit more context on why this bill is important to firefighters here in New Hampshire. It was mentioned earlier, some of the recruitment and retention issues that we're having. And as part of that, I'd like to share with you some numbers. Representative Pearson had mentioned what was going on in Manchester. I can tell you that that's a statewide issue. And that began, there's a clear delineation from the changes in 2011 to the retirement system. Just prior to that, in 2010, there were approximately 550 candidates annually that were taking the state entrance exam to become a firefighter. Those numbers clearly started trending downward once the changes were made in 2011. And now we're seeing somewhere around 150 to 200 candidates testing every year. in addition to that, what municipalities are seeing statewide is an increase in call volume. Take Portsmouth, for instance. They continue to build up. The call volume increases. They're bringing more people into the city. And the calls are becoming more drastic, right? We're dealing with a global pandemic, obviously. The opioid crisis is another big example of the ever-changing dynamics of the job. Unfortunately, when they're trying to staff these positions, they're creating new positions because the staffing needs to meet what's going on in the municipality as far as call volume. Unfortunately, they're unable to fill these positions because of a lot of things like the retirement system that have changed, that has changed the members' benefit over time. So we're seeing for every person that we're hiring in the state of New Hampshire, we're seeing 2 vacancies, which is a significant problem. In fact, last April, the state hit an all-time low with the number of candidates that took the test in that quarter was 39 candidates for hundreds of open positions throughout the state. It's a significant problem. And I think because you can draw the correlation to what happened to the retirement system in 2011, it's one that we realize that that's where the fix needs to start. The Department of Safety has recognized this to be an issue. They're working to develop recruitment and retention coordinator, recruitment and retention committees. They've identified this to be a significant problem too throughout the state, and one that we need to work towards a fix. I can tell you that we surveyed our members throughout the state to the point that this has no longer become anecdotal. Members that have left the job have told us in no uncertain terms that it's because of what happened to the retirement system in 2011. Members that are considering leaving the job have told us the same. And so I have serious concerns over what the fire service looks like over the next 10 years if we don't work towards a fix today. With that, I'd be happy to answer any questions that the committee may have, but I appreciate all your work on this, and thank you for putting some thought into it.
I have one question. In your opinion, does 1587 help fix the issue?
Yes. The short answer is yes. What I can tell you is we've gone through fire departments throughout the state, and we've talked to them about this issue. I can tell you that with all the changes that occurred to the retirement system back in 2011, this was one of the issues that wasn't one of the glaring issues because there was so many other bigger, nastier changes to the retirement system. This was one that kind of got lost in the shuffle.
Right.
But now that we've drawn so much attention to it, we've educated our members on it. I can tell you, firefighters, and I'm certain that the police officers can speak to the same, and corrections can do so. They're not happy because they feel like they were bamboozled to some degree. This one was kind of hidden, buried deep in the retirement language that it takes some time to dig up and really see what's happening here. But now these firefighters are realizing they're paying 11.8% on every single dollar that they earn to the retirement system, and they're not seeing that money at the end of the day, or at the end of their careers rather. So I would be lying to you if I sat up here and I told you I think that this is the silver bullet fix. Everything's going to be grand after this, but I do think that it is a significant step in a good direction towards maintaining and recruiting firefighters throughout the state of New Hampshire.
Okay, thank you. Any other questions? Yes.
Thank you, and thank you for all that you do. Certainly not easy, and I appreciate it and your testimony today. When recruiting or when discussing with new hires the retirement system, here they are brand new to the scene, what is the, I guess, elevator speech, in other words, the summary you would give a brand new person about the retirement system and the benefits offered thereof upon their joining?
That's a great question. I can tell you it more than likely it varies from department to department. What I can tell you is when I started about 16 years ago, the pitch was that to be a public servant in the state of New Hampshire, you worked hard. The money wasn't, you weren't going to get rich off of it, but at the end of your career, you were going to have a thoughtful pension that was going to be worth all the time and dedication that you put in towards a career in public service. I can tell you now, we're unable to make that pitch because of what the system is now. I will tell you, there's still, I'm not going to tell you your retirement at the end of your career is horrible now. I don't think that that's fair to say. But I can certainly say it's not a huge selling point for new candidates coming on now to let them know that, you may come in at $45,000 a year base salary, but if you work hard and you put in 25 years, you're going to have a good pension. And so I can tell you, Representative, at this point, we're not really using that much as a selling point.
All set. Any other questions? Yes, Representative Magoli.
Thank you, Mr. Chair. And just briefly, because sitting on EDNA, I heard a lot of this testimony, but I just want to reiterate that from what we hear with the shortage and the trouble of getting new recruits into the system relies on overtime to fill those missing positions. And that overtime that these employees are paying into the retirement system on and end up being their best years of their career, while they're being forced into that overtime, is it not true that they will not see a benefit for those extra hours paid?
Correct. Thank you for the question, Representative. Yes, so many of our members are being forced now to work overtime to cover these vacant positions. And because at the end of the day, we can't have fire trucks with no firefighters on them. We can't have police cars with no police officers in them. And we can't have prisons with no corrections officers. So these folks are being forced in to work in many cases, putting in hundreds of hours of mandatory overtime away from their families, away from their homes. And at the end of the story, the percentages that they're paying on all this overtime towards the retirement system, they're not seeing in their calculation at the end of their careers.
Okay, and I'll ask you again, does 1587 start to unravel that problem?
Yes.
Okay. Any other questions? Thank you for your testimony.
Thank you.
Anyone else? Yes, sir.
Thank you, Mr. Chairman. Thank you, committee members. My name is Michael Gia, G-E-H-A.
I'm sorry, repeat that again.
G-E-H-A. Michael. I'm the president of the New Hampshire Police Association, and I'm here today to convey our support for House Bill 1587. You have heard from others who spoke before me as to what this bill does. I want to take just a few minutes to explain to you why this bill is so important to law enforcement throughout our state. First, let me say that 10 years ago, when numerous changes were made to the state's retirement program, it was impossible to anticipate the circumstances that would develop like we have today. But some of those changes laid the foundation for hiring and retention problems by altering provisions and benefits that had been agreed to when some members were hired. Fast forward to 2022, the state of New Hampshire and just about every city and town are facing serious employment challenges in the public safety area, especially law enforcement. Our state have dozens of unfilled positions, and local communities are finding the applicant pool to be extremely tight. With that, cities and towns are competing against each other for not only the limited number of new hires, but in retaining existing personnel. Competition from other states, the private sector, and in some cases, outright burnout are adding to this very concerning public safety problem. I want you to know that there is a very concerning out-of-the-ordinary trend developing. The number of employees who are leaving before they reach their 20 or 25 years is very real. That is something none of us could have contemplated just a few years ago. The one tool that can help address this problem is strengthening the retirement benefits so there is incentive to stay for the full term. We believe HB 1587 is the kind of tool that will help in retaining those individuals who might be thinking about leaving early. And quite frankly, the economics make sense Local communities spend an average about $50,000 or more to train, certify, and equip each new police officer. Each time one leaves, the new hire training costs hit local budgets, and that's if the local community can even find new hires. We are very fortunate in this state to have such a dedicated, skilled, and qualified group of law enforcement officers, but the challenges are there for the future. I ask you to think hard about this potential crisis and to act before it gets worse. We all need to do everything possible to encourage these individuals to work their full pre-retirement terms. That's good for the safety of our citizens in every community. Keep in mind, being a police officer today is a challenging, stressful job. It is a noble profession. It's something that I truly love, but every minute on the job is filled with safety concerns. House Bill 1587 will help our state and local communities in their recruitment and retention of qualified police officers. I urge you to support this bill. Thank you.
Thank you. Any questions? Yes, Representative Hatch.
Thank you, sir.
You got to turn your mic.
Hate these things. I don't know if you have this information or not, but I think it's germane. Do you have a percentage of personnel that left the department early, say in 2010, prior to this, as compared to what leaves early now? I recognize the problem even within my community, but do you have some sort of numbers that correlates this or not?
I don't have an accurate number, sir, but however, every department has those numbers that we can possibly retrieve. There is, I hear it all the time, a lot of people that have 10 years or less on the job, they're leaving for the private sector.
If that was easily obtained, that would be interesting.
We'll try to do that, yeah.
Thank you, sir. Thank you, Mr. Chief.
Okay, Mr. Gia, could you have your testimony, can we put it in the file, please?
Absolutely.
Okay.
I actually made a couple copies.
Good. As I've stated before, it's our intention to help solve this problem. The question is, how much can we solve in this particular bill? I'd entertain a motion for the amendment, or do I have any questions on the amendment? Basically, it's the basic bill changing the dollar amount. Is that correct, Mr. Hoffman? I'm being videotaped now, so I want to make sure I'm saying the right thing. Right.
Remaining half would be considered in future budgets for the state and made up with employer contribution rates.
Okay.
A
Representation,
question,
yes.
Mr. Chair, if I could, and it's directed towards Representative Goley. You sat on the policy committee. Could you tell me what the vote was, or to support the legislation as it's been proposed?
I can look it up real quick. To be,
12 to 6.
12 to 6.
OTP 12-6.
Thanks.
Anybody else want to come? Yes, Mike.
Do you have a handout from the retirement system? They do a brief on each bill that kind of explains what the bill does, and then it has some examples on the bottom.
Okay,
Like me to
sure. We'll take all the help we can get. And I'll have read this by Friday. Without further comment, can I? Yes.
I'm very sympathetic to the bill, and I think we should do what we can do, but I know that we don't have the money to do 100% of it, and I think this amendment is a step forward to get us started, and if a motion is in order, I'd like to move that we accept this amendment.
Okay, the amendment is 1074H.
Second.
Okay, motion made and seconded. don't we do a show of hands? I don't think we need a roll call for this one. All those in favor of the amendment? All those opposed? Okay, the amendment passes 4-3. Okay, I'm going to close the hearing on 1587. Oh, yes, I'll reopen it and recess it till Friday at 1. Now we'll close the hearing. Okay.
Mr. Chair, is that the only thing I'm gonna do Friday? I have gel card too, but I'll come back to that.
We can do it right at the beginning. We're going to have 3 bills on Friday. Okay. It's tough to know where the preponderance of people are here for. So we'll take it off the, we continued 1535 until, recessed until today. So we'll open the hearing on 1535, the cost of living adjustments. Anybody want to make a comment on 1535? Yes, ma'am. I don't know, you gotta push the button. There
Push
we
the
go.
button.
There we go.
Okay. For the record, my name is Karen Irwin, and I am from the town of Hopkinton. Sorry.
Would you spell your name, please?
Sure. Karen, K-A-R-E-N, Irwin, I-R-W-I-N. I did hand you in a letter earlier, and I did send it out electronically to several, but you should have a letter in front of you. I'm going to speak to some of what I've said here, and this is regarding the cost of living adjustments for the state retirees. When this hearing was opened on this bill, it went in as being a reoccurring COLA for all. It ended up being amended to be a one-time COLA for those that were going to be 5 years out of retirement, had 60 months in before July 1st, 2017. It was going to be pre-funded or terminally funded, and that was amended by Representative Carol McGuire in ED&A. That bill got passed 17-2 and by voice vote on the floor. So I'm going to give you some facts and history here. We did a like COLA in 2019, basically the same kind of thing. This one is 1.5 as well, and it's on the first 30,000 per year. What I could find from the last Delennial Retirement Commission report was that in 2017, we had nearly 48,000 public employees that were active contributing plan members. That year, the trust paid $706.3 million in pension benefits to more than 35,000 retirees and beneficiaries, making NHRS one of the largest payrolls, the state's largest payroll. The average benefits with average benefits of 20,000. So if you equate the 1.5 times the average of 20,000, it's only $300 per year for each employee's COLA. That amount, from testimony I had heard, because the fiscal note wasn't initially done that way, it was estimated that in that particular population, 5 years out, we had about 22,000 retirees. So that calculation is $6,600,000 per year, all, assumptions, estimates aside. So what I went and did on the back page here is I kind of tried to show you, and that is a spreadsheet, tried to show you we're starting out with a terminally funded number of 79 million. And if, basically if you divide the 79 million by 6,600,000, you get 12 years. That would cover 12 years of people's pension. What I COLA. What I hope that you would consider is on either of these funding mechanisms that are being terminally funded, that you think about putting a requirement in the legislation that creates kind of a special fund, so you can see, and that they would get interest on that balance. So you would get at least the assumed rate of return, which is 6.75% right now, you know, on that balance. And that's what I did in the spreadsheet, is I rolled forward that amount from year to year, adding back, you know, an assumed rate of return is met every year, which it isn't always, but it has been on average met more than it has not been hit. So I guess what I'm asking you guys to do is to pass this bill pre-funded in some manner, to put a requirement in to create the special COLA fund, and to and for the assumed rate of return or whatever is the lowest on a state employee retiree account. If the return, like in 2020, is 1.1%, that's what we get into our account. If it's 6.75, I'm sorry, if it's higher, like 29.6 last year, then we get 6.75 in our account. Because these employees are 5 years out, I can tell you from my own numbers that before I exhaust my personal account, I'm 8 years out from my pension and any COLA that we would add, which is minor. And so you would have 3 years of, roughly 3 years, depending on how far people are. If they're between 5 and 8, they would have some of this money would be paid out of their account first. And so it wouldn't be coming out of the corpus of this account. It would be coming out of their personal retirement accounts, because that's how it works. Until you exhaust all your funding in your personal account, it doesn't come out of the corpus of the fund. So I hope you'd consider, because that was a pretty high number, but I can hear what you're doing with the other bills, so I hope you consider at least partially funding this one, if not totally funding the 79 million. I think that would be a step in the right direction, and it's much needed. We haven't had a regular COLA. We need to create a mechanism so that we can, you know, have those changes somewhere along the way, that we made huge returns in the last. So if you look down further, in my letter I quote again, at the close of the fiscal year, the retirement system's net position held in trust was 11.57 billion, an increase of approximately 2.44 billion over the prior year, an all-time high for the system. Additionally, it was stated that NHRS realized a 29.6 return on investments in the fiscal year ending June 30th, 21, well above the retirement's assumed rate of return of 6.75 and the highest one-year return in more than 30 years. It was important to note that these investment returns are for a single year, and we need to be considered in the context of portfolio's performance over time, and compared to the assumed rate of return, the 3, 5, 10, 20, and 25-year return periods were 11.4, 11.3, 9.3, 7.2, and 7.9 respectively. All returns are net of fees. As you can see, none of these cumulated returns, even out to 25 years, year return, are lower than 6.75. We had a factor, you know, at the time this bill was proposed, was that local government center and individuals were against it, even though it was modest, because they just couldn't support any more impact to their percentages they pay in locally. That's not the case here, you know, and so they were supportive of the bill as long as they'd have to pay for it in their rates. And so I do hope that that you will consider funding this, or, you know, and with the same kind of premise as what you just passed a little while ago, and I hope you consider that.
Any questions? Representative Leishman.
Thanks, Mr. Chairman. On Friday, there was some discussion about an amendment to bring this from 12 to somewhere in between. Is that still?
I do have an amendment,
Okay.
a rather kludgy amendment, now that there's more details, which will have to be amended, I'm sure. The idea was to try to do what we can in the current year.
Yeah. But it wouldn't be a one-time thing? It would be, go into their pension as a COLA like they would, I'm sorry, yeah.
Well, why don't you pass out the amendment? Because I think we'll probably have to amend the amendment then.
Okay.
But the idea is we concur with the concept. It's the dollars are a little of a stretch.
Yeah,
So this amendment basically makes it a COLA for the current biennium. And I pulled a number out of the air, quite
Yeah.
honestly, of
Yep.
$8 million. I wasn't off, you said it'd be 6.6 at 1.5.
well, that's what I had for facts,
Well,
so.
your facts are better than my facts.
That's what I could pull from reports. That's the most recent information I could pull, which is
Right.
the average of 20,000. And I heard the number 22,000 people. So it's pretty easy to do those numbers then.
Well,
And so
this works out to about $340 an individual.
if you, yeah, it would be more than you wouldn't need 8
It
million.
would depend on what your base is, what the percentage would be. I did it the other way around. If we do it from saying it's going to be a 1.5% COLA based on the dollars, then it's 6.6 million rather than 8. And we can fix that, whatever makes the most sense.
Yeah.
Because this is me making it up.
Yeah, it's considered a one-time COLA in this
Yes.
bill still, but it's meant to go into the base going forward. So that's where the bigger dollars come in. And I guess what I'm saying on my spreadsheet is we don't need quite that much money, but, from what I can see, because these people aren't increasing. They've retired for 5 years, and so I think if we add that one factor of making it a special count and then adding the assumed rate of return added every year this money sits there, that will be a huge gain on both of these actions, and I don't know if you have to put it in legislation to do that, but I think you would, but I don't know that. And I do think that's an important difference. So if I was to make an amendment to this, I would say it's not just a one-time, it's a COLA that we're going to try to fund going in the future. So I would change something to that effect so that they will get it into the corpus of their fund. And we should, if we doubled that, I would think we would have enough money to keep us going for a while. I don't know if you can do that, or maybe, I don't know. But I think what you would see in that reporting is you would see if they added the interest that it negates some of the payments, and it might not be as high as we think, and we would know more information going forward. Because I do like the idea that we pre-fund some of these expenses in the future. And so I think that will be really helpful.
Okay,
To-
other questions? Thank you.
Yeah, thank you.
And do you have a copy for a letter? You do?
Yeah, I
Okay, so
handed it out to
you have it.
everybody.
You have, all right.
Yep.
Okay,
Yep,
so I want to
thank
make
you.
sure it's in the file. Thank you. Yes, sir.
Thank you, Mr. Chairman. Again, for the record, my name is Arthur Beaudry. I represent the New Hampshire State Permanent Firefighters Retirement Association. I am a retired captain of Manchester Fire Department, and I was on the retirement system as a board of trustee. I'm glad we got to see this amendment before you adjourn today. I respect what you're doing, and I know there's only limited funds to give cost of living raises, but the concern I have with the amendment is B. And what you're stating is you have, anybody that makes over $30,000 would get nothing. Where at least in the past, the bill that's written, everybody would get something up to their first $30,000. So if I made $30,001, I wouldn't receive any stipend. If that could be changed to include everybody, then I can understand what you would try to do and actually would be beneficial to some of the lower income people, as I testified last week, I'll give you the number of people that make less than $23,000. It was a substantial number that make less than 20. It's 64% make less than 25,000. So if you're going to give them $340, that's actually more than a 1.5% raise, which would be beneficial to them because they're lower income earners. But to eliminate anybody that's making over the 30,000, I think you're going to be hurting a lot of people out there that are right in that fringe. So if that could be amended to
The
just
first 30,000.
the
right?
first 30,000,
Okay.
correct. And I would answer any questions.
Any questions? Thank you.
Thank you.
Anybody else like to speak on this bill? Yes, sir.
Thank you, Mr. Chair. For the record, Marty Carlin from the New Hampshire Retirement System. That's Karlon. Retirement system has no position on the original bill or this amendment. I just, for informational purposes, I just wanted to come up and share a couple of points. At your request through the LBA, we ran the numbers on an amendment with anyone who made less than 30,000, who was retired more than 5 years, and that's approximately 23,500 individuals receiving a benefit right now. So a one-time payment, you'd just be, multiplying the dollar amount of what you want to pay by X,
Right.
to get the bottom line. To Mr. Beaudry's point, the original bill was for anyone who was retired prior to July 1st of 17 or earlier, and I don't have an exact number on that today, but that was somewhere between 29,500 and 30,000 people. I can send that over to LBA.
Okay.
If you're interested in expanding it, again, you'd be tying the number by the benefit. And as a technical matter on the amendment, and I don't have language in front of me because I hadn't seen the amendment, but if I could propose the committee to consider another section just as it's got an effective date of July 1 of 22 if it passes, and talking to the folks on the member side and on the data processing side, we wouldn't be able to make that payment right away because there's a lot of programming to pull that together. So if I could send over some language about, this payment will be issued as soon as administratively practicable, no later than X. So, there's a drop dead date, but we just want to make sure we get all that program correct. I think the
Very good
18
idea.
one we got out like right at the end of August. Might be a little bit longer this year. We've got more projects but get it out sooner. But
Okay. If you would send that language, that'd be
Okay.
helpful.
and that's all I had. But I'd be glad to answer any questions.
I would be interested in if we modify this to be the first 30,000, not just those making less than 30,000, how many people would that be?
Sure thing.
If
Get
you
that
could do,
today.
if you could do that. That's what the intention of this was to get going down the road. So we're going to revisit this on Friday,
Okay.
okay? Thank you.
Thank you.
I feel like we're making progress. You got to put a tick on the wheel, but, we're getting there. Any other comments? Any other comments from the board on the amendment? Yes.
It looks to me like we're talking 29 to 30,000 people for the full amount, that we'd be reducing the overall amount by like 40%. And I think the people on the lower end are the ones that really need that money. So I think the way it's written helps the people on the lower end of the scale.
So make it just for people earning less than $30,000 annually.
That's the way it's written now.
Right.
I don't see the need to change it.
Representative Leishman.
Thanks, Mr. Chairman. I appreciate your efforts to provide some additional benefit through a COLA, but I do have a question, and again, maybe Representative Goley can help me with this. 1.5% or $340 as an average, I hate to say it, seems pretty insignificant or poor, I guess would be a better. Do you know where that 1.5% came from? Because I think Social Security went up greater than that this year. Yeah.
I'm not 100% sure, but I believe, you know, it was looking at what we could afford as a state going forward to help out these individuals, and this was going to be something that was going to be, when we looked at it, and it was put together by Chairman McGuire, was by terminally funding it, was to make sure that it stayed with them, because as we know, the last COLA we gave them, or stipend, we should call it, that they hadn't received anything since then, so now they continue to fall back because their pay hasn't gone up, where this was looking to fund it going forward so that they would have that money and they wouldn't lose it and fall behind, continue to fall behind as inflation increases. So, you know, I think it was just looking at a number that we could do something to try and help out going forward. And that was 17 to 2 out of committee, and it was a voice vote on the House floor for this proposal. And then I will say that it was for the 30,000, first 30,000 on all individuals, going back to that if you made 30,000 plus $1, you get nothing. And that was, I mean, those folks are still struggling at that end.
Right, okay. Well, the concept of this amendment is to not spend $80 million that we don't have. It's to make a COLA for the current biennium. I know we're going to have to revisit it, and we'll do that by Friday at 1. But I would appreciate a motion on Amendment 1073 so we can at least get the concept of a current year COLA on the deck.
Mr. Chairman, I'll so move that motion.
Okay, do I have a second?
I'll second it for discussion, Mr. Chairman.
Okay, thank you, Mr.
Thanks.
Leishman.
So I would be, you know, certainly being a fiscally conservative Democrat, support the idea of not going out 12 years or 20 years or whatever, and just keeping it for the existing period as the amendment states. But I would hope that we would do everyone for the 1.5%, not just those under the 30%.
Okay. So your modification to this amendment would be to make it at 1.5%.
Yeah, for the first 30,000.
For the first 30,000. Okay. Can I do a straw vote on this? Because we have two options. One is to say people making 30,000 or less, and the other one is everybody, but only on the first 30,000. So just a straw vote. If you're in favor of 30,000 or less as the option, raise your hand. Okay, if you're interested in all retirees first 30,000, raise your hand. Okay. All right. Then I would call for a show of hands on the amendment 1073. All those in favor?
Mr. Chair, if I may, I think from what we just did, we need to change the amendment before we roll it in.
I'm going to change it for Friday.
Okay, that's good.
Yep.
Thank you.
Okay, so all in favor of the amendment, and we will.
As it's gonna be changed.
No, as it is now. We have to vote on what we got, but I'm going to change it for Friday.
Mr. Chair, if I may, just for a procedural manner, can we not introduce this as is, because it is going to be changed? Just do it Friday.
That's fine.
This simple Dutchman, I mean.
No,
okay,
I
thank you.
just wanted to get the concept of it's a current year COLA only, and we're not going to solve the problem forever. So if
I agree with that, Mr. Chairman.
okay, then we will suspend a vote on this, and I will recess this hearing, this work session until 1 o'clock on Friday.
Thanks.
Okay, I think we have several individuals here for 1540, custodial interrogation. So I would open the work session on 1540. Do we have anybody who would like to speak to this? Yes, sir.
Good morning, Mr. Chair, members of the committee. My name is Buzz Scherr. Last name is spelled S-C-H-E-R-R. I am a police commissioner in Portsmouth, recently elected, and also a professor at UNH Law, where I've been for 28 years. For the record, I'm speaking on my own behalf. My opinions do not reflect those of either the Portsmouth Police Commission or UNH Law. I am in support of 1540. To go directly, what it does is it requires police departments to, in some fashion, record interrogations as defined in the bill. It does not require the recording if it doesn't fit the definition of where the location is. That is, roadside interrogations after a stop for a motor vehicle violation are not included in this. It is not. It's not going to cost police departments much, if any, money, because the majority of police departments at this point, including the state police, already record interrogations. Because the bill says it can be either an audio recording or an audio-visual recording, whether a police department has videotaping capability, though I think at this point most do, my understanding, even if they don't, they can use an audio recording. And I haven't heard of a police department, even the smallest police departments, who doesn't have the ability to do an audio recording, if only with an iPhone. But I think historically, I practiced as a public defender for 13 years, back in, as my daughter says, in prehistory, when dinosaurs roamed the earth, from 1981 to 1994. Even then, everybody had tape recording mechanisms. Even a small department like New Durham or Ossipee, where in the area where I practiced. So I don't think this is any financial burden whatsoever. It is also, I would add, as a matter of policy, I think it's good. It's good practice for police departments to do this for their own protection. One of the issues that's frequently litigated in criminal cases pre-trial is whether the individual invoked his right to remain silent or his right to counsel, or whether he waived his Miranda rights. And criminal defense lawyers litigate that frequently. The extent to which there is a recording of both the reading of Miranda and any waiver of Miranda and the entire interrogation, it's going to diminish the ability for those hearings to even occur, let alone be successful. Anecdotally, I'm aware of at least 2 states where the Criminal Defense Lawyers Association opposed this bill because they didn't want that to happen. There are 30 states who have some version of this bill, so we're not asking the state of New Hampshire to go out on a limb and do something nobody else is doing. As one of the, I would point out, I believe the National Innocence Project sent a letter to the committee in support of this bill. One of the most significant reasons that we see wrongful convictions in the United States. That is, convictions we know are wrongful because DNA evidence has exculpated the person convicted. Somewhere around 27 or 28% of those involve false confessions. It's really a stunning number if you think about it. And very often there are people with diminished intellectual ability, people who English is not their first language, or who have some mental health issues. And all those groups tend to be more vulnerable in an interrogation, which, you know, is a very, even for the average person, a scary circumstance. They tend to be particularly vulnerable. You know, that number is, I've been doing work with the Innocence Project since the first part of this century, and to this day that number is breathtaking to me, that there's that number of people who have been proven to have given false confessions, to confess to something they didn't do and end up going to jail for many years sometimes. So this is a relatively simple bill. It's pretty straightforward. It's not going to cost any money. It may cost a little bit for those departments who choose to upgrade to audiovisual recording. Other than that, I'm more than willing to entertain questions.
Any questions? Okay, thank you for your testimony.
Thank you.
Anyone else wish to speak on 1540? Going through this, one of the areas that I find a bit troubling is if you go to page 2, line 23, it speaks to presumption of inadmissibility. And my reading of this, and you can correct me if I'm wrong, my reading of this is that if you are doing recording and subsequently take any testimony unrecorded, it negates your recorded as well as that which was not recorded. I knew I was reading it wrong.
I wouldn't say wrong, but that provision, the baseline of that provision is if it's not recorded, that you can show that there was a good reason for it not being recorded, and therefore it will get past that presumption of inadmissibility. So it's not an absolute, it's never going to be admissible. Lack of a better way of putting it, it shifts the burden. If it's unrecorded, then you got to show there was a good reason for it being unrecorded. Now, if there's a recorded confession, and the subsequent confession happened in a set of circumstances that fit the legislation, that is, it's not a, you know, random comment somewhere where recording was not possible, then that presumption will apply. But then again, you still have the opportunity to show that there was a reason for it. So the idea is we recognize we don't want to make the circumstance of recording confessions too rigid. We want to appreciate that. I would use an expletive, but it would be inappropriate. That stuff happens, and I think there's flexibility in the bill to deal with those circumstances. So it's not a rigid, if you don't record it, it's not going to come in, be it after an originally recorded confession or even at the front end. It's it's up to you now to show us why it didn't get recorded. And I think my expectation is courts will be pretty charitable for reasonable excuses.
Would it be inappropriate to put in there that it could be written and signed and not recorded?
I think that starts to get to a situation that's problematic for this reason. Most of the Innocence Project wrongful convictions that involved false confessions involved signed confessions. So it's not it's not a provision that would give the kind of protection that this bill is designed to give, to be very straightforward with the chair. It's a lot easier to create a circumstance in which someone is falsely confessing for whatever reason, and all they have to do is sign it. You know, frequently you see some of the cases out there, wrongful convictions, you see the police wrote the confession for the individual and then they signed it. For example, in a ESL circumstance, English as second or third or fourth language, very frequently you see the police wrote the confession and then the individual, and they say, just sign this, now that we read this and sign this. So that provision would take away the kind of solid protection that this bill is designed to give.
Yes.
Thanks, Mr. Chairman. I was just curious if anyone was in the audience from criminal justice, because I actually find your take also problematic as I read this, but not to put our member to my left on the spot who is an attorney, if she has any comments, but it seems a little problematic to me.
As written.
As written.
Representative Mooney.
Thank you, Mr. Chairman, and thank you for your description as well. I do see that clause, as a legislator now, talking as a legislator, quite strict, to the contrary of what you're saying. So definitely some language here to reflect your comments about there being a reasonable excuse or a good reason and so forth for the recording not taking place at the time. Because words in this provision like not, all, any, shall, that is rigid.
Two answers. One, I don't have the legislation right in front of me, so I can't give you direct comment.
That's highlighted with a pen.
Thank you.
That's page 2, lines 23 through 27.
I have it.
And while you're reading that, I'll just make a comment. I did talk to the Department of Justice, head of the criminal division, and his reading on this is that it could punish a victim. If an officer doesn't follow this, and this, the victim gets punished because it's inadmissible. So that was their concern with this. Yes, sir.
I'm not sure that's, well, let me go step by step. I was present when criminal justice heard this bill. This concern was not addressed. I see that Representative Welch is also here. He's the prime sponsor on this. But it was not addressed in criminal justice. I had during my testimony, for example, I had a very heated is the wrong word. I had a very engaged back and forth with the person I view as Justice Lynn, former Justice Lynn, now Representative Lynn. He did not have a problem with that provision. He was very comfortable with that provision. So, so that's part one. Part two, I think 594A5 has to be read in the context of 594A6, which says it talks about overcoming the presumption. I don't think 595A5, lines 23 through 27, can be read without also thinking about the following provision, 594A:6, where it says the presumption of inadmissibility of statements provided in A5 may be overcome. And any statements that were not electronically recorded may be admitted if the court finds, et cetera. So that's where that flexibility comes into place. And I believe, and I welcome further questions from Representative Leishman or Mooney or the chair. I believe that takes care of the concern that if you read A5 independent of A6, I would have also. I mean, I don't want this to be a rigid bill. I was very involved with Representative Welch in drafting this bill, and the goal was to make this, put some flexibility in there, and I think that does it.
Okay. Comments?
Just going to add, thank you for that, and I would make mention, I would amend that section A5 reference then A6 to avoid the trap we just fell down.
I mean, I have no problem it reading A5 reading except as provided in RSA 594A:4 and RSA 594:A6. If it's that language were added in there, I'm completely comfortable with that. Not that my comfort matters.
Well, to keep us out of the pit.
And Mr. Chairman, just quickly, a gentleman from the audience would like to comment as well at your discretion.
Okay.
Thank you, Mr. Chair. My name is John Sonia. I'm a lieutenant with the New Hampshire State Police. I am the commander of the Homicide Bureau. My last name is spelled Sonia. And just listen to the testimony of Professor Scheer. I was a little concerned, as you pointed out, Mr. Chair, but I do agree with Representative Mooney that a fix like that would probably be necessary to reference that next area in the statute. I appreciate you referencing the DOJ. I think it's more applicable that they speak on. This is a lot of legislation. It's 2 pages full of amendment. And even when I read it this morning, as Professor Scheer just did, it becomes complex, especially if you're doing it for the first time, as he just indicated. So it's I think some examination is appropriate, as you did on this committee. What that means, if that means, again, coming back Friday and asking DOJ to send a representative, I think it's not only important to make sure that it doesn't conflict with itself, but it doesn't also conflict with other statutes and laws. I know that some of the first testimony brought by now Major Ebert was it could conflict with some of the one-party statute laws also. So it's important with legislation this long and this wordy that it, I guess the legal scholars do have input on it and maybe come in to testify before you presenting that. So I could take any questions from the committee that they might have also. Again, I just read it this morning also as a fill-in, but that was part of just listening to testimony. I appreciate that. I think it should be amended to address
Right.
kind of a forward look.
Any other questions?
No, I think John's got a great idea, because I look at line 30 on page 2, and then we're using the word may be admitted again, so I'd really like to hear from the Justice Department, and because I still share the concerns that you have, Mr. Chairman.
Okay.
But overall, our homicide unit does practice utilizing at least audio recordings. So we feel in the last few years we've been at the forefront of this. I think it is important to really button this up so it can be utilized in the future, but not be limiting because some language was missed in there.
Okay. Thank you.
Thank you, Mr. Chair.
Now I'm going to lift the hood on the car for another issue. That is, this appears to be a downshift piece of legislation that we're requiring recordings. I mean, at least when you start reading it, it sounds like here's what you're going to do, and if there's an associated cost with that, then we get the downshifting problem. I would suggest that we change this to be an enabling legislation that says if you're going to do recording, this applies. If your municipality, town, elects not to do recording, it doesn't apply. So that we're not forcing recordings. Thoughts from anybody? Representative?
I appreciate your point, but as pointed out, I think most or proponents of individuals who take confessions have access to some sort of recording device without an additional purchase by any sub-political division of the state. I mean, And to have this optional, in my mind, would bring us back to right where we are right now. And why even bother doing it if it's optional in my mind? But I could be wrong. But that's, I think, correcting the language so it's clear and understandable, I think would probably be the best approach. But
Okay.
thank you.
Any other thoughts? Yes, sir.
Thank you. Mr. Chair, if I may, because our homicide unit travels throughout the state, the point is well taken that there are some departments that are very small, and even though we can make the assumption, as been stated in testimony, it doesn't cost them a lot, it's easy to do, it may not be. It may not be in Colebrook, New Hampshire, where we've been on cases, because their resources are much more limited. Along with the same conversation about making sure the language is correct and it kind of covers all the bases and not jumping forward too quickly. It might be taken into account, like we had mentioned, we all seem to have cell phones nowadays. We have more ability to record than ever before personally. However, when we talk about the recordings for criminal cases in court, that is evidence. It becomes evidence. We get issued digital recorders in our unit. So each detective, homicide detective, can take that with them anywhere they go. That availability isn't everywhere, but it's also evidence. You're recording criminal evidence on that device, and then you're producing it to court later. So another concern might be to button up the language, because small departments that may not have policies and procedures as the state police do, we're able to take that medium, copy it to a disk, a thumb drive, pass it on, memorialize it as evidence, and then pass it forward to prosecution, maintaining that chain of custody. Not everyone has that, and we certainly might want to button up the language so we're not having local police departments just utilize their personal cell phone. That could become evidence in a criminal case later on, or examined for that purpose. So there is maybe more thought process to go into the legislation to talk about policies, procedures for the overall New Hampshire law enforcement community as far as departments and within consideration of their various size.
Okay.
Any questions for me on that?
Go ahead.
Thanks, John.
Go.
It would appear to me, and again, you've been doing this a long time, but having recordings of interrogations or whatever is probably more beneficial to the department to prove perhaps what was said or going on versus just some written statement that someone could challenge later.
Absolutely.
Yeah, thanks.
Works for me.
At House Criminal Justice, and Public Safety, we talked about the issue of chain of custody, again, a good part of that was with I'm going to call him Representative Justice Lynn, and I think the general feeling was when you make policy changes, when you want to make policy changes, it is not a sufficient reason that police departments will have to develop new policies not to make the policy change. I mean, I think change to some extent, to the extent this is a change, it's not a dramatic one, means some police departments may have to develop certain policies, but the state police has a policy on this. Some other Portsmouth, of which I'm quite familiar, has a policy on this. That they can import those policies from other departments. So I don't think that the concern about policy change at the department by department level is one that gets in the way of this. And second, we can talk about this forever, which I hope not to, in spite of being a law professor. But it's not going to cost money. We're not done shifting costs. We just aren't. It's if a officer in a very small department records it on his personal iPhone, he can very quickly send that to the prosecutor in the case. And that's not going to be a chain of custody. I teach a course called Evidence, which, among other things, I teach students about the rules surrounding chain of custody and getting things into court. And that procedure I just described will be sufficient. You don't have to document every step. You just have to have the officer come into court when the recording is played and say, yep, I listened to that recording just before I came into court, and that's what that person said, and this is a recording of what that person said. That will take care of the chain of custody circumstance. So and we don't want to try to legislate at a statutory level chain of custody issues that really don't exist, or to legislate what policies individual departments have to deal with audio or audiovisual recordings. I think that's exactly what police departments do all the time. They develop policy and they share amongst each other policy changes. So I think that's I think this is good legislation, and I think cost-wise, there's going to be no burden on police departments, and policy-wise, it's a relatively minor adaptation on their part. Hopefully, hopefully John doesn't have a response, so I don't have to get back up again.
We need you to use a microphone so that anybody watching the video can.
And I wouldn't normally, again, Professor Scheer, I appreciate everything you just said. It just, you keep using the word no cost, no cost, no cost. I guess there is a cost to somebody. And there are some police departments that make them purchase their own firearms. And as we know, firearms for a handgun is not astronomical, $300 or $400. All I'm saying is there are departments that have very low funding in this state. I go throughout the state. So every time the word no cost is repeated, it's a cost to somebody. Just that consideration is all I'm asking. And I know we talked about evidence a little bit. My point being that if you mandate, or a police chief mandates, well, just use your own personal cell phone. Again, that's a downshifting of cost to somebody. It may not feel like it, but you're putting on that officer to now utilize something he pays for to do a recording for his job to comply with the law. So I just wanted to add that to the conversation.
Okay, thank you. Yes.
Thank you. Yes, sir.
Yeah, thank you for your testimony. I have a question. If an officer uses his personal weapon as well as his personal phone, isn't that a liability issue on the department?
Not for the department. The department's going to have that training. They're going to take him and get him certified on that weapon to utilize it. Now, if he utilizes it in the course of his duties, that weapon is probably going to be taken as evidence, going to be seized by my unit of the state police that does officer-involved shootings, and they may not see it till it's adjudicated. So you would lose the weapon, and you'd have to theoretically go buy a new weapon. But it wouldn't impede the system. It's just something that they allow their office to do, and then they'll go to the range and get certified on it per police standards and training council criteria.
Okay, thank you for that clarification.
You're welcome, sir.
Other questions or comments about the bill?
I appreciate the point of it will cost somebody something, and I probably don't want to give up my iPhone for evidence and lose it for a while, but on Amazon, I just looked up real quick, you can buy a little recording device for $29. Just, that would be adequate for something like that. So there could possibly be a cost, but cost benefit, I'm not sure we're there. Thank you.
Well, my point was that we're finance, and
Yeah,
I was trying to see what effect this has financially, and that's the only place that I saw was the potential downshifting. Yes.
Yeah, I agree with you, Mr. Chairman, because again, if you look going back to page 2 on line 6, these interrogations at a jail, police or sheriff's station, holding cell, correctional or detentional facility, those are all costs. I mean, someone's going to have to bear those, whether, at a detentional facility, do they have that capability now? I assume the Department of Corrections does, but I don't know. But there's definitely a cost here, in my opinion.
Well, that's why I said, do we neuter the bill if we make it enabling legislation? And basically leaves us where we are right now, to Representative Hatch's point. Or do we want to have an idea that we're trying to affect policing in the state. Yes.
Thank you. So just to get back to your thought about an enabling legislation piece, an exception almost for the small departments that Officer Sonia referenced, would you be adding a section Roman 3 on page 2 to A4? Because there is an exception provision. So despite all this very harsh, shalls, nots, alls, any's, and so forth throughout, there is a large exception section that could, with the right language, make provisions for the departments that may not have the funds to record.
What line was that again?
Line 35? No, I was actually referring to page 2, adding it between lines 22 and 23. So it would be part of the A4 exception section, which is headed on line 11 of page 2.
Yes.
Roman numeral 3 on the bottom is the exception. You're talking about moving that kind of language up there to be part of the initial paragraph, or not? Or am I talking about two different things?
Well, I was thinking that if we were to add a Roman 3 to A4, which starts on line 11, section A4 starts on line 11. If we were to add a Roman 3, that would address the financial exception, almost like a financial exception provision.
And that would cover it, right? And that would take care of that concern.
Yeah.
Thank you.
So the financial I'll get it out in a minute. Exception would be if you can't afford it, this doesn't apply.
Yeah, yeah, and that's.
That's fine. Then it's not.
Right?
Yeah. Yes, sir.
Yeah, under A6, I think the financial circumstances of if it's the Freedom, New Hampshire Police Department, and there's nobody there who has a cell phone. They don't have any kind of tape recorder. They don't have any kind of audiovisual equipment. I think they fit under under A6 in terms of ways explanations for them not having not being able to record it. I think that that is the point of that exception. We don't want to make this so rigid that in the circumstances I just described in the Freedom, New Hampshire Police Department, we don't want to make it so rigid that that exception can't be that kind of explanation. The reason we had the broad A6 is we can, because this is unambiguous flattery, because they're all smart people, we don't want to be a circumstance where we all come up with yet another exception we need to add. Once you start adding exception after exception after exception for individual circumstances, I mean, you're, I'm sure, more familiar than I am what a mass legislation turns into when you do that. That's the point of A6. We're going to leave it to judges. If it's one of those departments, I don't, I used to have practiced in front of every Superior Court judge, but I'm so old now that most of them are retired. Although some of them are now my students, that's how old I am. I can't imagine a judge in the circumstance I described not saying, you've overcome the presumption, and that we're going to admit this. We don't want a circumstance where a very small police department loses a case and a victim doesn't get the kind of justice that they're owed simply because of that. And that's why that exception is there. It's intentionally broad because we want to leave it to judges, informed by prosecutors, informed by defense lawyers, informed by lawyers for the victims. We want to leave it to judges to figure out, is it a reasonable exception? So
Thank you, yes.
Hopefully I can keep
Representative-
John quiet. but-
Representative Goley.
Thank you, Mr. Chair. I'm glad he's pointing out that section, because in reading it, part of A6 states that for purposes of this statute, mere inconvenience or financial expense shall not be considered reasonable justification. So I'm reading that to say that they shall expend the money to get the equipment, because that will not be reasonable.
Yeah, I think yes and no. They don't. If they've made a conscious decision not to spend the money, that's one thing. But if it's a circumstance that the only member of the department who has the tape recorder, or it's being used in another circumstance, or the only member of the department who has a cell phone is not there, and it's 3 a.m, then I don't think that is. That's what that contemplates. That said, yes, it's possible that there is a police department out there and that doesn't have the basic tape recorder. I don't know of anyone that does does not have a physical tape recorder, and I think in the theory of this being a downshifting of a cost is there. I appreciate that. But in reality, I just don't think it's very, very unlikely that it's there. And as Representative Hatch pointed out, it's very, very simple. And if we're downshifting the cost of $50 to the smaller police departments in return for the greater impetus behind this legislation, that is, we want to have some more protection within reason. We want to have some more protection against the possibility of false confessions, and balance that against some smaller police departments will have to spend $50 more. I mean, that's the consideration that I want all of you to make, and I appreciate all your concerns.
Yes, one more cycle.
I couldn't do it.
Thank you. Based on what everyone was just talking about now, I do agree with the point over here about when you read that, it does limit it. And I appreciate Professor Scheer mentioning that it's kind of nice to leave these up to the judge. Is there a way to make mere inconvenience shall not be considered reasonable? However, financial expense would be up to a judge to determine if that was reasonable. I guess that the limiting language of you're putting in here shall not, you're saying it. The judge is going to read this and say, well, I can't do anything with that. But again, if we allow the court system to be the court system and weigh things in different areas, maybe a change in the language would be beneficial for that reason, to kind of tighten that up and allow the court to decide.
Representative Gold, do you have any thoughts on that one?
The only other concern, there's continued talk about just voice recordings, but if you look on page 2, lines 3 through 7, if they are in a custodial interrogation at a jail, police, or sheriff's station, holding cell, or correction or detention facility shall be recorded by audio and video. So it's not just a tape recorder.
Not or. So if it said or, it would work better than and.
And in agreement with that, part of the limiting language is it's talking about the whole facility. So I would imagine that the Department of Corrections or the county jail system would probably say that would be a huge cost to them, because they'd have to have that ability to audio and video record every portion of their facility, not knowing when you're going to have some kind of custodial questioning take place.
Yes, Representative Griffin.
Thank you, Mr. Chair. For the purposes of the statute of mere inconvenience of financial expense, what happens if we just delete that sentence and we rely on the law and the reasonableness of it?
I'm comfortable with the amendment that John suggested in terms of the financial circumstances, or Representative Griffin's, and I'm certainly comfortable with making the and or as before. And I'm willing, for what it's worth, I'm willing to incorporate all that we've talked about into an amendment and offer it and send it to the chair and the members of the committee just for drafting purposes. If that's appropriate, I don't need to, but
Okay.
I can't be here on Friday. I am in Washington, D.C. learning how to build police stations.
Oh, sounds enlightening. Right, yeah.
Your point is noted.
So on line 7, if it ended shall be recorded, period, then we can go back to the definition of what recordings are.
Yep.
Is that acceptable? Okay. Now, as far as line, what was it, Jerry, 37?
Yeah, the sentence that starts at the end of line 36 and goes to through 37. If we just delete that, then we're back to the 594A6 or 4 or whatever it is that talks about the reasonableness of the thing.
Right, so then the judge is not looking at this as an instruction at that point.
And would Representative Griffin, how would you feel about that language, or financial circumstances, unless a judge were to rule well, actually, I'm trying to build in a mechanism for the judge to. I'm just concerned that some departments are just going to say, all right, we don't have to do this because we don't want to pay the money. And it's $50. I mean, that's my concern. So I'd like a judge to have an opportunity to evaluate whether the financial circumstances are legitimate. I guess that's my only hesitation on what Representative Griffin is talking about. I've been a lawyer too long.
I'm going to say you know too much.
That's what my students say.
Yes, Jerry.
It seems to me like you made a good case about 594A6, I believe it is.
Yep.
That it leaves a lot to the judge. And my problem with the last sentence on page 2 is that it takes it away from the judge. If we just get rid of the sentence, then we're back to some flexibility.
I'm fine with that.
Mike, are you taking notes? Okay.
Just one
Yes.
suggestion.
Representative Mooney.
So, to Representative Griffin's point, line 36, what if it read, of the surrounding facts and circumstances explaining the lack of recording which may include financial expense? Here now, the judge would have at least some direction and an example for why there wasn't a recording, and that may include the financial expense piece.
Does that work?
I certainly wouldn't have a problem with that.
And you would put that
At the end of the prior sentence.
end of the first sentence?
The end of line 36. So in other words, it would read, of the surrounding facts and circumstances explaining the lack of a recording, which may include financial expense. And then delete the very last line of the bill, starting with the words, for purposes of this.
My only suggestion would be to delete out of that last line or financial expense. I'm a little hesitant to delete inconvenience. if that's appropriate. I mean, I think given what you've suggested earlier, adding which may include financial expense, I think we can delete or financial expense from that last sentence, but leave in the word inconvenience.
Yep, that makes sense. Because looking at this from 30,000 feet, it looks like what we're trying to do is codify best practices.
Yep.
So I think that just did it.
Ideally, I will get this to the chair later this afternoon
Okay.
and to the members of the committee.
No, we'll take care of the,
You'll take,
oh yeah, we'll redraft this,
okay.
and we'll get you a copy.
I appreciate that. And somebody else, either from the National Innocence Project or somebody local from the local New England Innocence Project will be here on Friday while I figure out how not to spend money and still build a new police station.
Okay, thank you. Thank you, Mr. Scheer. Yes, Mr. Hoffman.
Can we review the end of the page again?
Okay, I believe on page 2, line 7, ends, shall be recorded, period. Then, page 2, line 36, lack of recording, which may include financial expense, be added to the first sentence. The second sentence stays as is, with the exception of or financial expense is deleted. So it says mere inconvenience shall not be considered. So the inconvenience is left in, but the or financial expense is deleted. Yes, good morning.
Thank you. And then one additional to that list,
Oh, right.
if we're in agreement, is line 27 to make reference to section A6. It was the earliest of the conversations
Right.
related
Correct.
to an amendment.
So it's including A6 and A5.
Would it be appropriate on line 23 where it says accepted as provided 594A4 and 594A6
Yes,
Yes.
that works.
instead of 127?
It gets it up front, and so, yeah. Okay, any other comments? Gee, the ones I thought were gonna fly through were bogging down. Okay.
So we're gonna have a long day Friday.
Well, it's just got longer. Okay, so. All right, so that, 1540 is in recess until 1 o'clock on Friday. Okay. Hope we got some simple ones here.
Yes, Mr. Hoffman.
Yes, sir, certainly.
Mr. Hoffman,
Could turn your mic on.
are we still live? Did you check, please?
Thank you. We're still live. Okay. I would open the work session on House Bill 1647 relative to calculation of child support. Does anybody have any comments they would like to make on this bill? Members of the committee, any emails, phone calls that would sidetrack this in any way? Because as I read through this, I certainly have no expertise in this one. Yes, Representative Mooney.
Thank you, Mr. Chairman. I would just like to point out that last evening, a relatively very detailed email came in related to this bill. It looks like it's from what's called the Child Support Working Group, with a membership list that was below, including Mary Kruger, Aaron Jazina, Bill Woodbury, Honey Hastings, Anthony Malo. Sorry if I mispronounced the name. And quite a bit of information here. It did come relatively in last night. It would be good to talk to someone from the Children and Family Law Committee if they were present, but other than that, I
Let's see, this 16.
would be interested in hearing more.
This came out of committee OTP 8 to 7. Yes, Mr. Representative Griffin.
I think our job is more the financial cost of this bill. And it seems to be indeterminable. And so that's my question is, what would the financial cost to the state be? I suspect a lot of that would be U.S. government money, if in fact there is a cost. And hopefully the policy committee has received the information that you have received and has looked at it.
Yeah, I have to look at this one and say the policy committee, to me, trumps any idea I would have, because I have nothing to contribute to this. Mr. Hoffman, do you?
I was just going to point out, we do have a couple of representatives from the department, if you'd like to hear from Health and Human Services.
Anybody like to comment on this legislation?
Briston, is that how you say it? That's right.
Morning.
Go ahead.
I'm Susan Brisson. I'm the Chief Staff Attorney for the Department of Health and Human Services Bureau of Child Support. And also with me is Lisa Dekatowski.
Okay, could you repeat your name
Sure.
slowly, please?
Susan Brisson, that's Brisson.
Okay, got it. Thank you.
You're welcome. The department doesn't take a position on this bill, but we could address some of the issues with regards to cost. We did do a fiscal note for it. I think our biggest concern is when you start with, well, first it changes the self-support reserve from 120% of the poverty level to up to 150%, which is going to result in more minimum orders for child support, which could then result in families receiving public assistance. So less child support, more public assistance, which would then be a cost. It's unclear to know, how many of those cases would happen, but that's our first concern.
What's your second concern?
Well, the second concern is making sure it has language with regards to that the change in the law is not then a reason for the parties to come to court to change their child support order, because that would be basically a run on the court, expenses to the court, expenses to the department. But that's kind of sort of just a technical
So should
issue.
there be language in here that addresses that?
There should be. Forgive me, there are three separate child support type bills right now. So which one has which language is kind of muddled, but we are making sure that gets handled.
Okay. Questions from the committee? Yes, Representative Leishman.
Thanks, Mr. Chairman. So your department, do you see any additional staff required? Because the judicial branch says there'll be more time needed for judges, case workers, marital masters, that type of thing. Let's see what else. Because of the increased amount of work for the judicial branch, I would assume they may have some costs. They said they're indeterminable, but do you see a need of hiring additional staff at the department, your department?
I mean, we haven't had those concerns. it's more the issue of time, which could lead to the need for more staff, but it might just be a delay in all cases. If each case takes longer, things just sort of get pushed down the road a bit. These guidelines are turning our current guidelines are making them a lot more complicated. They're similar to what's going on in the state of Vermont right now, and it's just longer, more complicated. Obviously, we'll get better at it as we go, but it's more discussion about parenting time will then result in having because the time will then go into how
Finances.
many nights, what's the analysis, and that type of thing.
Mr. Hoffman?
just-
Oh, I'm sorry.
I'm sorry, just a quick follow-up, Mr. Chairman. So your response concerns me because we all know here that the department is hundreds and hundreds of employees short now. So by saying this was going to add more of a burden, going to delay things, that would be a huge concern of mine and probably shared by everybody here.
Well, I mean, I would say it's a concern. What the level of it is always the question. It's unclear to me what the actual change will be, because the cases we deal with, there's sort of a range of people. We deal with people who don't even. We have child support orders that don't have parenting orders themselves. They just deal with it. They either get along or they don't get along, but they don't have, court-ordered parenting. So that's where I sort of look at these and go, okay, well, how are we going to deal with that? Because of the issues of, he says, I've got the kids, 5 nights a week, and she says, no, I've got the kids 5 nights a week. I'm not sure. At least my office, then we have a hearing, which is probably where the court is looking at, more hearings, but.
Mr. Representative Hatch?
I need to be caught up because when you're saying parenting, you're talking about amount of time for custody for each custodial parent? Is that what?
Correct.
and-
The term custody is not something that we
and-
use, right?
Well, whatever. Just so I understand it. Thank you for your tolerance. Who adjudicates the fact that when the non-custodial parent doesn't pay their fair share, or however you want to say that goes to the courts?
Correct.
Correct. Ergo, the need for more judicial staff or whatever in the courts. But that, again, you're saying that will not have any effect on your workload to the point that additional staff may be needed? Because I would think there's a correlation between the two, if I may. That's what I'm trying to,
Well-
unless I don't understand what's going on, other than I know my bride counsels many young ladies who are without a husband home and don't get any support and very little help in achieving that, but that's neither here nor there, so.
Right. Child support has two big areas that we sort of divide into establishment and then enforcement. And this bill, I think, lands in the establishment realm, and it's what should child support be? Then once there's an order, whatever the number is, then we run into enforcement, and that's a different different area that I'm not sure this bill would affect that much, because the order has to be enforced whether it's $50 a month or $500 a month. Sure.
Yeah. Representative Griffin?
Thank you, Mr. Chair. I wonder if I could ask you to monetize. You said there would be a cost. Is it $1,000, $100,000, $1 million, $10 million? What do you estimate the cost may be of this bill?
I don't have the skills to be able to do that, unfortunately.
And as a follow-up, if I may, who would pay that cost?
Well, I think we've already had some discussion that, I mean, if it's more hearings, that's from the department, that's definitely the court. If the parties have to come to court more, or if there are more hearings, they have their sort of assigned costs. I'm sort of speculating. We don't deal with cases that have too many attorneys on the other side. It's usually us, and then the parties are unrepresented. But if this gets incredibly complicated, like it sounds like it could, there might be more people who need attorneys, and they'll end up having to deal with that cost as well, to have an attorney help them walk through that process.
Thank you for your testimony.
Any other questions?
Thanks,
Go ahead.
Mr. Chairman. So could you tell me what this self-support reserve is, and where does that money come from?
The self-support reserve is a number that's based on the poverty level, which is set by the federal government. And it's not a figure that's paid. It's a figure that's used when calculating child support, and it's supposed to represent what the person who pays child support gets to keep for themselves in the first instance for their own very basic needs. Like right now, it's easy to remember because it's $1,234. So in the math, at a certain point, when you get down to income that's available to pay support, you subtract out the self-support reserve. That income is reserved for the payor, and then anything that's left over is what child support would come out of.
Okay. Thanks, Mr.
So
Chairman.
that's per month?
Correct.
Okay.
It's due to be reset in April. Every April, the new guidelines are set, and the self-support reserve goes up generally a little bit.
Okay. Mr. Hoffman, do you have a question?
Well, regarding the possible run on the courts, the bill as amended has an applicability clause at the end that seems to limit it to new cases. I didn't know if that would ease the burden on the courts as opposed to the bill that was introduced.
Okay, good. Yeah. Page 4, starting at line 25, it's got the language that this act shall not constitute a substantial change in circumstances for the purposes of 458C7, which is the modification language. So basically it says that just because this law has changed, that is not a reason
To revisit it.
to revisit it. You can't go in and say the law's changed, I want a new child support order. There has to be a separate reason.
Okay.
So that's very helpful on that end.
We won't have piling on.
We would hope not.
Okay. Other questions? Thank you very much.
Thank you.
Oh,
Excuse, I have a question. What is your correct title for the record, please?
I asked her for a card.
I'm Chief Staff Attorney.
Thank you very much.
You're welcome.
anyone else like to comment on this? Seeing none, what's the pleasure of the committee? Or the division, I should say. Not all at once.
I'm more confused.
I haven't got a clue. Yes, sir.
Yeah, yeah, Mr. Chairman, I'm just kind of curious, this almost seems like a Division 3 issue.
Yeah.
And maybe run it by them first, or, a lot of this is, we generally don't deal with it, as you know, the
Yeah, that's what I'm
Department of
saying,
Health
that-
and Human Services, so,
I think it ended up first because of the judiciary.
yeah, maybe. I know we're a difficult lot over here and pretty thorough, but a lot of questions came up, again, from the Chief Staff Attorney for the Department of Health and Human Services that maybe
Well, as much as I don't want to, we will recess this until Friday at 1 and try to get some reading from Division 3.
Thanks.
Good submission.
Yeah, put it on the bus. This should be an easy one.
You said that before.
1496, requiring physical subdivisions to make motor vehicle checklists, voter checklists available in spreadsheet. This is saying they can give the voter checklist out in electronic form instead of printed copy. I certainly hope we can all agree that's not a problem.
Mr. Chair, I would move ought to pass
Oh,
on
my gosh.
House Bill.
My heart.
We haven't heard that in a while, but
No.
on 1493, ought to pass.
A motion made and seconded.
Sorry, 96.
1496.
1496 ought to pass.
Okay, OTP. Let's call a roll, and, because hopefully we're going to get one through.
Hold on, okay, a motion is not to pass, right?
Yeah, ought to pass.
Okay, it was made by Representative Mooney.
Mooney,
Second by?
Griffin.
Okay. Okay, I'm all set. All right, if you're in favor, you'll vote in the affirmative. If not, you'll vote in the negative. That being said, Mr. Chairman,
Yes.
Vice Chairman,
Yes.
clerk votes yes. Representative Mooney,
Yes.
Representative Eastman,
Yes.
Representative Hatch. Yes. Representative Goley.
Yes.
It's unanimous, Mr. Chairman. 7-0.
Okay. That being done, I will close the work session on 1496, and I would open the work session on House Bill 1552, which is the last bill under consideration today. Establishing a board for certification of assessors. Does anybody on the committee have any comments? Or does anybody here have any comments? Please.
Good morning, Mr. Chair, members of the division. For the record, Lindsay Courtney, Executive Director, Office of Professional Licensure and Certification.
Spelling, if you'll ask.
Courtney, Courtney.
Got a card.
Thank you. So OPLC does not take a position on this bill. We provide administrative support to over 54 licensing boards, so this would add another one. And I think there's some legislation in the works that would also bring the Boxing Commission over to OPLC this session.
And horse racing?
What's that?
And horse racing?
We don't have that yet,
No.
so I'm sure that'll come up soon. I just wanted to provide some observations to the division because there are some pending legislative changes that I think could impact this bill if it were to be passed. The first would be there was a recent amendment to Senate Bill 330. In the bill, it would recognize that licensure can have an impact on workforce, and that would establish a study committee to determine how we license and certify individuals in this state. Obviously, that would take some time, but presumably any findings that come out of that study could impact if this bill were to go forward. So I wanted to let the division know about that one. And there's also, it's my understanding, an amendment that may go forward to Senate Bill 313, specific to funding. There have been a lot of discussions among stakeholders about the appropriate way to fund the office, who should determine fees, how fees should be allocated. Right now, the office currently has statutory authority over most of professions in terms of setting fees. But we know, being on jail card, that the boards have retained some of that authority. So this amendment to Senate Bill 313 would establish a study committee. What came out of conversations to Senate Bill 313 as introduced was that there are disputes among stakeholders as to what the mechanism for funding the agency should be. There are challenges when you seek to require that the licensee, that the agency be completely self-supporting, and if the cost allocation is based on a consistent licensure fee, that there are certain individuals who may not be able to pay their fair share, so to speak. So this committee would look at that. There have been suggestions that maybe we move away from self-funding the agency. I don't think that would go very far. That's my personal opinion, but that obviously that report could impact, I think, what would happen with this board. As it relates to funding, you, I think, saw the fiscal note. We assume that this would be a completely self-funded board like the other boards. The average cost of shared services for a license in OPLC is $155 for 2 years. So that would be what we would propose that the certification fee should be. We don't know how many individuals are actually licensed. We also don't know how much support would be required. We classify all of our boards based on identifiers that we worked with the Division of Personnel on into A, B, and C boards, depending on how much support they need. My assumption is that they would fall in the middle, like the real estate appraiser, so they would have a dedicated board administrator and maybe a license clerk, but until we start working with the board to determine the complexity, it's not clear how much would be needed in terms of staff support. But in any event, I'd be happy to answer any questions that you may have. I appreciate the opportunity.
Representative Griffin.
Thank you, Mr. Chair. My question is, having served as a selectman in a fairly small town, we were the Board of Assessors. Who would this bill affect? Would it affect professionals only, outside people who charge for their service? Or would it affect staff in a city and town level?
So I'm going to defer to the department DRA on that because I'm not intimately familiar yet with the assessors. My understanding it would be just certification of the professionals only. That's correct.
Thank you.
Okay. Other questions? Yes, Representative Leishman.
Thanks, Mr. Chairman. Thanks for appearing. I didn't see in here that this may go back some time, but there's a portion or a couple of areas on, like, for instance, on page 6, line 5, as far as the assessing of fines and violations. Is there an appeals process for that? Because I didn't happen to see it, but I may have overlooked it. But I was just curious, if you assess a $2,000 fine, is that appealable to somebody?
Yeah, so that would be considered disciplinary. So one is entitled to due process, a notice, and an opportunity to be heard. We did seek a legislative change last year that did get passed. So all appeals go to the Supreme Court. And some of the board, I think one board had a mechanism to go to Superior Court and then go to Supreme Court. It didn't make sense to us that you would have to go through a couple of different steps. I will say, though, that's, from a policy standpoint, that can be concerning because who's going to spend $20,000 on an appeal to appeal a $1,000 fine? So, the state may want to look at that when if there were to be a study committee on occupational licensing, because I can tell you that it's usually only physicians, a handful of, maybe dentists who actually appeal decisions of a licensing board.
A follow-up, if I could, Mr. Chairman. So we're looking at assessment, and as Representative Griffin pointed out, bringing the DRA into the picture. Now, the DRA has a procedure for appealing assessments, and then they have an internal body, and that can go to the Board of Tax and Land Appeals. So I guess what I'm hoping is that somewhere down the line you do something internally so somebody doesn't have to go to Superior Court. And then the final question, if I could, Mr. Chairman. So it says that you have all these powers. For instance, to administer oaths and affirm affirmations, subpoenas, witnesses, compel people by subpoenas. What is there statutorily something that what am I looking for? Like your credentials for hiring of this job? Do you have to be an attorney or hold, be a justice of the peace or? Because you've got pretty broad powers.
It's not required, so I'm appointed by the governor and approved by council. I am both a JP and an attorney. But I will say the statute, I think, is crafted off of, first of all, I don't take a position on whether I should have this powers, or I didn't craft the statute, but I think it's based on the real estate appraisers. And I will say it's very common for state statutes to delegate authority to a commissioner or an agency head. It's not actually that person who historically carries out all functions. If you look at, commissioner of HHS, for example, if you look at the DHHS statute, there's a lot of requirements that the commissioner do X, Y, and Z. That's usually delegated either via rule and policy and procedure after internal controls are established. So this would typically be done pursuant to a particular rule and procedure.
Okay, I just had never seen that, Mr. Chairman. It kind of caught my eye that not, putting you on the spot, but the position has those immense powers.
Another, oh, yes, Representative Goli.
Thank you, Mr. Chair. And sitting on eDNA, we deal with all the licensing, certification, and registration bills. And this did come to the committee 18-0 with these recommendations because of what we heard from Revenue Administration, and transferring these folks over, it only made sense to put them in their own board in a separate statute under OPLC.
So that's the problem this is solving.
I'll defer to the department on that one.
My name is Carolyn Lear, L-E-A-R, and I am the Assistant Commissioner at the Department of Revenue. So I would say from the department doesn't take a position on this bill, and I would say from the department's perspective, there actually isn't an issue to be solved here. This was a bill, I believe, that was requested by the assessing community. Based on a recommendation from the Assessing Standards Board, which is an administratively attached board to the department, but is not the department. So the commissioner has one seat of, I think, 12 seats on that board, but it's primarily made up of either professional assessors or local assessing officials. The rule framework for assessor certification is also from that board, and the department really just administers those rules as it relates to the certification process for assessors, which we are happy to continue doing. I wish there were assessors here today to tell you why they thought it was necessary to transition the board from the Department of Revenue to OPLC. To summarize what I understand their concerns to be, without speaking for them formally, the Department of Revenue has a pretty ironclad confidentiality statute that makes most of what we do at the department confidential. And my understanding is that the assessors are dissatisfied that the certification, and specifically the assessor discipline process, when complaints are brought against assessors, falls within that confidentiality umbrella. And they propose to fix that with this transition of the certification function from the Department of Revenue to OPLC. That being said, there is another bill making its way through the process, Senate Bill 53, a holdover from last session, which should be crossing over to you, that takes a more direct route and makes assessor certification records public. So rather than transition the board entirely to OPLC, it would simply make those records public and available for the public to see.
Much like a real estate license. You
Yes.
can go online and see if somebody has a real estate license.
Yep.
Okay. So this, now I'm starting to understand. So what this bill does is basically move the assessor's functionality, supervision, whatever, over to OPLC from DRA.
That's exactly right.
So we're really not changing anything, we're just moving it over?
There are some substantive changes to the makeup of the certification board. As I had mentioned, the Assessing Standards Board, which sets the rules for assessor certification, has about a dozen members intended to represent both large towns and small towns, municipalities, as well as taxpayers. The commissioner has a seat on that board, as well as several legislators. The makeup of this board before OPLC is much smaller, and therefore represents fewer of those interested parties in its makeup.
It was cut and dry before, but now it gets confusing. Yes, Representative Griffin, go ahead. Oh,
I'll speak to it after.
okay, go ahead, Representative Leishman.
Thanks, Mr. Chairman. So I appreciate you saying that you're not taking a position, but reading that between the lines, it kind of sounds like the DRA isn't entirely happy with this legislation?
I wouldn't say that, no. I would say that property taxes make up a huge proportion of the tax burden in the state of New Hampshire. And the assessors, the certified assessors that value property have a hugely important role in ensuring the fairness of that process. So I wouldn't say that we're opposed to moving them to a different agency, but I think it should be a very carefully thought out decision to do so that those interests continue to be protected.
And if I could, Mr. Chairman, so I've sat here a long time and seen a number of DRA commissioners, and there's always been the greatest respect, and you folks do a good job. And like I mentioned earlier, there's an appeals process within the agency, within a certain bureau, and they work well with taxpayers. So I guess gut feeling is I think the DRA has done a good job overseeing assessing in the state and appraisals. We recently had a problem in Peterborough, and the department sent people down to talk with taxpayers. So I'm just a little concerned of tearing that oversight away, if you will, and giving it to the OPLC. That's my concern.
I have that thought as well, and I'm pretty familiar with the OPLC, being on Delcar for many years and adjudicating their rules, and I'm very comfortable with the current structure of the OPLC. But then, again, going to my concern, I don't know if the same structure exists within the OPLC to adjudicate some of these concerns with assessment values like the DRA currently does. I mean, the OPLC handles physicians. I mean, they handle a myriad of very important functions. They handle a wide range of subjects and do a very good job at it within the boards that they oversee. What we need to understand is the OPLC, all they do are supposed to do, it's a consolidation of different boards and handle the administrative functions of a myriad of boards. And I don't know if within the OPLC that they have the wherewithal and the uninterested party to adjudicate some assessment concerns like we currently have in the DRA. And I'm not sure that I understand enough what the OPLC would incorporate from the DRA to have that same adjudicative body with the expertise that the DRA has currently. So I would have to get a lot more information before I would even, but I'm not a policy guy, I just do finance. But this
Representative Goley.
this is concerned.
Thank you, Mr. Chair. And once again, I like to think that the ED&A committee, when we look at these bills and these boards and certifications, do our due diligence when we do it. And my understanding is in doing this, the OPLC will be just reviewing the criteria for the licensing and registration of these individuals. It will still maintain DRA's ability to deal with the assessing standards and the assessments that go on and anything that needs to be adjudicated in that sense. The board is not, OPLC is not taking over that aspect. They are just taking over the licensing procedures and maintaining those licensees and taking the board under their scope of practice versus DRA. DRA still maintains all the assessing, and any discrepancies that go on still goes through them and not through OPLC. And if I'm wrong, please correct me.
Representative Griffin.
Thank you, Mr. Chair. I'm coming at this from a very different perspective than everyone else, I guess. I look at both the DRA and the licensing board as being part of the executive department of the state. And as such, it seems to me that if there's a need to make a change, it should be coming from the governor and his staff instead of from us as legislators. But over and above that, I was very pleased to hear that the Senate bill, there is a Senate bill that is addressing the major issue here, which seems to be pushing the bill forward. And I just hate to see, the assessors pushed over into licensing board. Inevitably, it will raise the cost of hiring an assessor. And it just grows the bureaucracy. And it's part of the executive department, and if the governor and his managers feel like they need this bill, they're the ones that should be pushing it and sponsoring it, and I don't see that happening. So I plan to vote against the bill.
Anyone else?
I'll second Representative Griffin's motion.
I'll move that we
ITL?
ITL 1552, HB 1552.
Okay, do we have a second? Or you seconded it, okay.
May I just add something to this? We're not, a couple things here, and that's part of why I went on my tirade that I did, is we're not a policy committee, and we're voting this down based on the lack of policy. Now, understand that the OPLC, and that's my point, has taken over a myriad of very important licenses for individuals to assure they fall within the compliance of whatever board that exists within their auspices. And we're really not changing the way the earth rotates here, all right? All we're changing is assuring that the licensure of assessing individuals that are tasked, given that task, meet within a certain standard as decided by their board. We're not changing the way the earth rotates. All we're doing is changing how the administration of that, and probably if the same thing follows as it did with a myriad of other licenses we have in this state, it will only improve that process and make it a little better. And that's what's currently happening. So I'm not at all opposed to this, and I trust the policy committee did their due diligence in an area that I'm not that familiar with. So I would not vote for ITL on this based on that.
And this came out of the policy committee 18-0. Yes, Representative Goley.
Thank you, Mr. Chair, and if I may, and being on that policy committee, it did come out 18-0 and was passed on consent for this policy. One of the other main reasons which you heard earlier, which we can talk about a Senate bill, but we do not have it in our possession right now. If we don't do anything, we still are going to have that 91A issue that was talked about earlier. This was one of those ways to address that issue that was brought before the policy committee. The policy committee reviewed all its options. This bill was amended, as you can see, with an amendment to make it better and address the concerns that were brought forward, and therefore went to the House floor as a unanimous recommendation. So I can't support ITL after that being said and those votes being taken from the committee that their main focus is dealing with licensure and that.
Representative Leishman.
So sticking to this, the financial aspects of this, we're creating an assessing certification board. We're establishing fines, which there is no appeals process. And looking at the fiscal note, I think there are about 200 individuals that will be assessed a fee of $155. So I'm just, there's some cost. We're creating a board of, I don't know how many different professionals that will obviously receive some sort of pay, actual travel by new board members. So I guess I stand by my second. Even though there are some financial implications, and the thing that bothers me about assessing fees and fines is a process where you don't give someone an easy way out to appeal and force them to go to Superior Court, and that costs money.
Okay, Representative Griffin.
Just to add to Representative Leachman's remarks, usually when people get into, professionals get into the licensing board, the requirements for continuing professional education get enacted, and they tend to grow over a period of time. And the costs of those doubled, really. The assessor would have, if he's required for continuing professional education, he'd have the cost of the education itself, plus he'd have the week or 2 weeks, in some cases, that he'd lose to do his job, basically. So there is a cost to it. It's kind of a disease that our society suffers from. The more we legislate, the more we put into law, the higher the cost of everything becomes, because there is a cost with.
Okay. Oh, I'm sorry. Yes.
Thank you, Mr. Chair. And I would state that from DRA that there is a cost for these folks currently who are registered and licensed without this board being in place, that there is a cost for their certification currently, and that if they do no wrong, that there's no recourse and no fines or violations for these individuals? Yes.
So there currently is no fee for the certification license before the DRA. So that would be an increased cost difference. I tried to quickly look at our rule, the Assessing Standard Board's rules, because those rules do set forth the types of discipline that can result. I don't believe we can issue fines, but I couldn't quickly get them on my phone. My experience has been at the department for the past just under a decade, we have never issued a fine. The types of discipline that we issue when there's a determination that there has been some sort of assessor wrongdoing is typically a period of downgraded certification, license suspension for a period of time, or education requirements, taking classes to sort of remediate the misunderstanding that led to the error. I'm not sure if it's that we just have never issued a fine or if we don't actually have the ability. I couldn't quickly locate that in the rules.
Thank you.
Go ahead, Representative Tavares.
Okay, thank you. Given the recent problems we had in Berlin with our assessing board, I just wanted to make a comment. I'm not in favor of ITLing this bill. As a result, the DRA, we disbanded our assessors, which are appointed by the judge and the city council. As a result, the city council now acts as the board of assessors. I think this bill is definitely needed to proceed with doing some type of correction to make sure that they're qualified. So I will be voting against the ITL motion.
My difficulty with ITL is a policy committee coming out 18-0. I have to say that they know a lot more about this than I do, certainly. So I would have to not support ITL. So with that said, there's a motion made and seconded. You want to call the roll?
Sure, thank you. Chairman votes
No.
the vice chairman.
Yes.
The clerk votes no. Representative Mooney,
No.
Representative Leishman,
Yes.
Representative Hatch. Representative Goley.
No.
Okay, the motion is 2 to 5, so the nays, the motion does not pass.
Okay, I'll make a motion.
Okay.
Ought to pass.
All right. Do we have a second? Okay, seconded by Representative Hatch.
Okay.
I'm going to call the ought to pass roll.
Okay, I will do that. Okay, let me do this differently. Okay, the chairman,
Yes.
Representative Griffin.
No.
The clerk votes yes. Representative Mooney,
Yes.
Representative Leishman,
No.
Representative Hatch. Representative Goley.
Yes.
Okay, the motion is 5-2 in favor of the pass motion.
Okay. With that said, HB 1522 will go as OTP. And that concludes this hearing, or this work session.
Yeah. Yeah, pauses it.
Today.
3 days of hell followed by this.
Can you make sure that Janet knows which one got rescheduled before?
Yeah, I will. Yeah, there's only 4 of them.
And if anybody needs a copy of the calendar and the amendment.
I usually get it in the mail. Oh.
One on the end of the cabinet.
So Representative the Burge, all your towns, like your selectmen act as a board of assessors.
Say that again?
All your towns, I served as a selectman for 14 years, and you actually, the select board or city council, whatever, they serve as a board of assessors for that community.
Yeah.
None of the people you would
Yeah.
target would
Right.
have been licensed.
No,
Right.
they're not licensed.
Because that's what the Burge said he didn't like, because now he said the other overseers.
They're an appointed public board.
What's that?
Well, we'll have to do that.
Well, I know that.
I don't want to come back again. Thank you.
All right.
We may not be. It's still flashing over the. Oh.
Remember, we're still on live.
Friday's the 18th, no? What's Friday, 18th? 18, yeah.
Yes. And there's a channel. For some watching this on YouTube. So you go to New Hampshire House of Representatives Committee streaming, that's the channel. But this particular stream is called House Finance Division 1, 0314.
You can also access it from the House calendar.
Yes.
If you scroll down,
And there's a link.
and there's a link, and then you get to choose which one of